it's helpful to think of two different types of self-determination, and that each of these are very important rights, but they're different in nature. So the non-self-governing people have the right to become self-governing, and the indigenous people have the rights of indigenous people that are recognized now, and I'll go into this in more detail. And these are separate rights, and they're very important rights. And so here in Guam, we have two different types of self-determination that can be pursued. The people of Guam as a whole, who are not self-governing, have the right to be self-governing. The Chamorro people have a separate and distinct right to self-determination, to autonomy, to their lands and their resources, and that's very much a right that they should be allowed to pursue. The Chamorro people are indigenous people, and the United Nations, as I'll talk about in a moment, has recognized the rights of indigenous people in a declaration passed in 2007. They have a lot of important rights. Indigenous people have lots of different kinds of experiences in different areas, but typically they meet these criteria. They were here before other people came. Frequently they're not the majority. They have distinct cultural differences, and they identify themselves as indigenous, and they feel very strongly that they are distinct and different and want to continue that way. In the Northern Marianas, the indigenous people are the Chamorro people and the Carolinians, who are grouped together for purposes of this issue in the Northern Marianas, and they have this wonderful word, Rafalawash, which they use to recognize this sort of combined indigenous people that they have there. And in the Northern Marianas, the rights of the indigenous people are protected in a number of distinct ways in their covenant, that only people of Northern Marianas descent are allowed to acquire long-term or permanent interest in real property. So that's an extremely important distinction that's been carried forward, and that distinction is in the covenant, and it was insisted upon by the Congress, because the Congress during the Trust Territory period had worked very hard to maintain the land rights of the Micronesian people, and so as the Northern Marianas became a commonwealth, they wanted very much to maintain that special status, and so that's now in the CNMI Constitution also. And they define the persons of Northern Marianas descent as a person of at least 1/4 Mariana or Carolinian, Chamorro or Carolinian blood, or a combination thereof. And they again go back to the 1950 period, the same date that's in the Guam Draft Commonwealth Act, as the defining moment as to when you classify people as being Northern Marianas descent. And the Ninth Circuit, the U.S. Court of Appeals for the Ninth Circuit, upheld that provision in the Wobble case in 1990. This might have been controversial if it had been in one of the 50 states, but the Ninth Circuit says, our Bill of Rights was not intended to interfere with the performance of our international obligations, nor was it intended to operate as a genocide pact for diverse native cultures. Its goal purpose was to protect minority rights, not to enforce homogeneity. And the court has this very interesting language saying, absent the alienation restriction, the political union between the CNMI and the United States would not have been possible. So it was a deal, and the courts of the United States are willing to uphold that deal. And they also have a unique way of having their Senate made up with 3 members from Rota, 3 from Tinian, and 3 from Saipan, even though there are large population differences, and the federal courts have upheld that as well, even though it clearly is not consistent with the one person, one vote rule that would normally apply. In American Samoa, they also have restrictions on land ownership. You have to via 50% Samoan blood to own land in American Samoa, and that's been upheld. They have lots of special provisions for the Matai, who have to be Samoan, have to be 50% Samoan, and so that's been upheld in a series of cases, the most important of which is this 1987 case. So we have pretty good law that that the rights of indigenous people will be upheld, I'm now going to spend a moment talking about the Declaration on the Rights of Indigenous People, which, as I said before, was adopted by the General Assembly in 2007. It was adopted by 143 to 4. Now, one of the 4 that opposed was the United States, along with Canada, Australia, and New Zealand. Since this, Australia has said that they now support it. Canada is in the process of saying they're going to support it, and I'm hoping our country will support it quickly. But even without that support, it's clearly international law now because it was adopted by such an overwhelming vote. And it talks about the right of self-determination of indigenous people, and it then explains that in some detail: autonomy, self-government, access to financing. The indigenous people do not have the right to secede, but they have the right to live as distinct people, and they could be protected against any form of forced assimilation or integration. So this is very powerful language, and it goes on to then, in a lot of detail, talk about health, education, media, housing, religion, and so on. And in each of these areas, the indigenous people have the right to autonomy, to govern themselves and govern their own resources. Article 26.1 says they have the right to the lands, territories, and resources which they've traditionally owned or otherwise used or acquired. So they have the right to their land base. And of course, that's going to be interpreted in different ways in different communities, but it's clearly an important right that they have. And indigenous groups insisted that they be called peoples rather than minorities. So this is a very important distinction. That minorities, of course, have rights. They have the right to be protected from discrimination. But a people have rights that go beyond that and have the right to self-determination, which is the right to autonomy and the right to govern their resources and themselves. So the UN has set up a permanent forum on indigenous issues. There's a special rapporteur, Jim Anaya from the University of Arizona, who coordinates this, and Professor Anaya has worked with a lot of indigenous communities. This is an important case from Nicaragua involving the Awastingi people. And indigenous people, of course, can be found around the world in many different ways. In Taiwan, the government is doing everything they possibly can to honor their indigenous people and allow them to maintain their traditions and their knowledge. In Scandinavia, the Sami people, the Laplanders, have their own distinct rights. In Japan, they recently recognized the rights of the Ainu people as separate and distinct peoples. In New Zealand, Aotearoa, there's been a long process whereby the Maori people have been able to recover lands and resources. And you see this list of settlements with the various Maori tribes, or iwi, which has gone on over the last 3.5 decades, which has led to a lot of real things of value, land, but not just land, factories, ships, fishing rights. And this is one of the more recent settlements involving forest land in the North Island that's gone to 6 of the iwi there, 5 of the tribes, very important settlement. And this is the longest river in the North Island, the Waikato River, and it's now being managed, co-managed by the Maoris in that region, along with the government. So the Maoris are now players, very substantial players in their community, and New Zealand is recognizes itself as a real multicultural, pluralistic place now. So indigenous people have rights